reasonable expectation that they won't be recorded. A wire communication is also a spoken or otherwise oral, with an AU, communication, but only those that are transmitted over the internet, the telephone network, or the like. Third and finally, electronic communications are any transmitted communications that are not wire communications, whether they contain text or images or video or sound or any other sign or signal. Unless you are a party to a communication or have the consent of a party, intercepting any oral, wire, or electronic communication is a violation of the statute. So, for example, secret monitoring of your emails while they're being transmitted, wiretapping of your telephone calls, or secret eavesdropping using a microphone planted in your house would all violate Title III. However, the secret use of a webcam or a radio-controlled camera to photograph you inside your home or office or other private space is not currently prohibited by Title III, because in such case there would be no oral, wire, or electronic communication to be intercepted. At most, the only communication would be the electronic communications between the camera and the person who's remotely operating it. And that person is a party to those communications, as opposed to a third party intercepting those communications. So Title III simply doesn't apply. This has been held first in 1984 by the Seventh Circuit in United States v. Torres, in an opinion authored by the esteemed Judge Posner. Multiple circuit courts have since agreed with that court. The Second Circuit in U.S. v. Biasucci, the Fifth Circuit in U.S. v. Cuevas Sanchez, the Tenth Circuit in U.S. v. Mesa Rincon, the Ninth Circuit in U.S. v. Coyo Mejian, the Eighth Circuit in U.S. v. Falls, and the Third Circuit in U.S. v. Williams. These decisions, most of which were denied review and therefore implicitly affirmed by the Supreme Court, were typically in the context of an appeal of the denial of a motion to suppress video evidence in a criminal case. But this logic has been followed uniformly in other civil cases as well. In the year 2000, for example, the Court for the Eastern District of Pennsylvania held in Audenride v. Circuit City Stores Incorporated that an employer's use of a silent video surveillance system in an employee's office did not violate the Wiretap Act because it did not record sound. Nor did my client ever record any sound to accompany the video taken by Mr. Zuckerson's webcam. Therefore, following a stack of precedent that the prosecution cannot counter with any case law, that charge must be dismissed. I would also like to note, Your Honor, that the prosecution has notably failed to provide sufficient evidence for the felony enhancement for the 1030A2C computer fraud and abuse charge. There is simply no evidence that my client had a commercial motive or was seeking a personal financial gain from his conduct.
All right, thank you, Mr. Bankston. Is there anything more to your argument on the Rule 29 motion?
No, Your Honor.
All right. Let me ask you a couple questions here, particularly on your first argument about the request to dismiss the wiretapping charge of oral communication. Does your argument depend on the defendant, assuming the defendant was engaged in this activity, being a party to the communication by having enabled the webcam?
No, Your Honor. It primarily turns on the definition of an oral communication, which I don't have this statute in front of me, but is essentially a communication by the human voice that is intercepted in circumstances where the person has a reasonable expectation of privacy. So for lack of that recording, there is no oral communication. And I'd further argue, to the extent there were, one could argue that there was no expectation of privacy in this party. But most importantly, oral communications are communications of the human voice, period. And this video recording did not capture any communication via the human voice.
All right. Thank you, Mr. Bankston. Mr. Ohm, do you have any argument in rebuttal?
I do, Your Honor. Wonderful arguments, I might add. So just to make sure I understand the scope and scale of the defendant's motion, this is targeting count 1 and count 3, if I followed you correctly?
I think he made a general Rule 29 motion, but in particular he was challenged.
So yes. let me take count 3 first. And as I understand the hastily stated and ill-supported argument, it was that the government failed to present any evidence that would prove the financial motive for the third count, the hacking count, which is necessary for the felony conviction. The government agrees that we have to show commercial advantage or private financial motive, and the government argues that that burden was met, at least for the Rule 29 phase, by the testimony of Agent Stroker, who brought in the two pieces of email that talked about, number one, the $5,000 honorarium that came to the defendant a mere few days after the revelation of this material, and almost more importantly, number two, the uptick in users to his own service, the 75% increase in users, which I think is sufficient for the government's burden at this stage to show the motive that's necessary to sustain the felony. So that's on that one. On count one, and just to make sure we're all on the same page, this is about the interception of the silent video. The government concedes that the defendant has an impressively long list of precedent to suggest that silent video, for some reason, does not amount to a wiretap violation, and if by mere happenstance the microphone had been enabled as well, this would amount to a federal crime. And so the government has several responses to this. First, as a textual matter, and I do have the definition right here, and I love this because it shows that Congress understands the concept of head recursion. Oral communication means any oral communication, and then it goes on to say, uttered by a person, and then there's more. And so the first thing the government would argue is, essentially Congress has left this undefined. The only thing that were provided is that the crime is for the interception of an oral communication. And the government argues that that's exactly what was intercepted in this case. The people, and I understand the jury hasn't seen this, but you have, Your Honor, the people are very visibly and very clearly moving their lips throughout the video. And because oral communication remains undefined in the statute, or mostly undefined, we just fall back on the normal, ordinary English meaning of these terms. And I think if we pull out the ordinary English definitions, they're capacious enough to include situations like this where we can't even hear. But more importantly, the government would argue that as a matter of policy, what the defendant is arguing is very, very troubling. So the defendant is arguing that this statute, which is the primary principal comprehensive privacy statute for the protection of things like oral communications, wire communications, electronic communications, basically has a loophole that's big enough for a Mack truck to drive through. That basically, for whatever reason, Congress in its inestimable wisdom thought that they were going to regulate in a very fine-tuned way what we say, what we send on the wires, what we send electronically, in all sorts of things, and yet for some reason leave completely unprotected, for example, a video camera placed inside a locker room, or a video camera placed inside a shower or a bathroom. That just cannot be the case that Congress would have such an odd omission. The last policy argument that the government would rely on is to remind the court, as you know well, that this statute is not just a criminal statute. That this statute also governs the behavior of the police and of law enforcement. And that a ruling that Congress meant to exclude silent video in criminal cases would also mean that Congress meant to exclude silent video in law enforcement cases. This would basically be a license, a blank check, to all government law enforcement to install silent video cameras wherever they want, for any reason, without the statute, which again is the primary arbiter of privacy when it comes to things like interception. This would say that the statute has nothing to say whatsoever about this wholly invasive law enforcement technique. And so for all of these reasons, we urge the court to deny both motions. Thank you.
Thank you, Mr. Rahm. Mr. Bankston, do you have any other rebuttal to that?
I do. The law doesn't have anything to say about this especially invasive surveillance technique that could be used by the government. And if this were a policy debate, I would agree with my esteemed colleague on the other side of the courtroom. In fact, I have testified to Congress saying that a good policy was, in my role as an EFF privacy advocate, that it would be a good thing for Congress to update the law in this manner. Judge Posner, over 25 years ago, suggested that Congress might want to look into this and update the wiretap law to cover silent video surveillance. But it has not done so. And we are not here for a policy debate. We are here to determine the fate of this man. And whether I or Mr. Ohm or anyone else disagrees with the policy decision that Congress made when it wrote this law. It did make that decision, and that is the law that we are considering today. As for the outrageous suggestion that silent video where you can see people talking is the capture of the content of an utterance of the human voice, I'll simply say that 7 circuit courts of appeal have decided as a flat rule that silent video recording, including of people who may be talking, is not covered by this statute. And so I think that's all I have to say.
Thank you, Mr. Bengston. And I should say I'm very glad we asked the jury to leave, because this, of course, is the kind of thing we wouldn't have the jurors listen to. But I've heard the argument and given it consideration and have seen the briefs as well. And based on what I've heard today, I'm ready to issue my ruling. And on count 1, I hereby...
And we will now take a mandatory 15-minute break and return with Judge Salgado's decision after everybody's had coffee.